Welcome back to the deep dive. Today, we are plunging headfirst into a subject that manages, well, the greatest financial failures in the world.
Everything from global shipping empires all the way down to a single household just struggling with medical bills.
We are talking about bankruptcy, and right off the bat, we have to clarify what it actually is.
We do, because people use it all the time as a synonym for insolvency, and they are absolutely not the same thing.
That's the critical starting point for this whole discussion, isn't it?
It is. Insolvency is just a state of being. You can't pay your debts, you're broke, your company's underwater.
It's an economic condition.
Exactly. But bankruptcy is the legal status. It's a specific court-ordered process that allows an insolvent person or a company to seek relief. It's the formal mechanism for dealing with being broke.
Okay, a legal tool, not just a financial state. And to get started, the name itself has this surprisingly dramatic, almost physical origin story.
It really does. It sets the tone perfectly for the brutal history of debt. The word comes from Italian.
Bancarotta.
Banca rotta. Literally a broken bank or a broken bench.
And the story behind that is incredible. It supposedly comes from Renaissance Italy.
That's the tradition, yeah. In places like Venice and Florence, the early bankers and money changers would work from a simple bench, a banca, in the public square.
Okay.
And the story goes, even if it's a bit of a legend, that if a banker defaulted and couldn't pay his debts, his bench would be physically smashed. Rotta. Broken.
Wow. So it wasn't just a notice in the paper, it was a public physical act of destruction.
A total public shaming. It was a visual metaphor that told everyone your financial life was over. And that really sets the stage for our mission today.
Right. We're going to track that journey from that kind of brutal punishment.
All the way to the highly structured rehabilitation-focused laws we have today. We'll look at global differences, the complex U.S. chapters, and that very fine line between a smart legal strategy and outright criminal fraud.
And that's the tension that runs through all of this, isn't it? How do you balance the rights of the person who is owed money with the need to give an honest debtor a fresh start? To really get why rehabilitation is such a big deal now, we have to look at what people were being rehabilitated from. So let's go way back, thousands of years, to ancient Greece.
In ancient Greece, failing to pay your debt wasn't just about losing assets. It was about losing your freedom.
What do you mean?
Well, there was no concept of a fresh start. If you couldn't pay, your creditor had the legal right to seize you, your wife, your children, even your servants, and force you into debt slavery.
So you repaid your debt with years of your life, with forced labor.
Exactly. Your body became the collateral. But even then, there were some early sort of legal limits.
Protections.
In a way. In many Greek city-states, debt slavery was often capped maybe at 5 years. And these debt slaves had certain protections for their life and limb that, a regular slave captured in war might not have had.
But I remember reading there was a really dark loophole to that.
There was. While you, the debtor, might be protected for 5 years, your servants, or even your own children who were seized with you, could sometimes be kept by the creditor for much longer.
For a lifetime.
Sometimes, yes. Under much harsher conditions. It was a way to get around the limits on the original debt.
That's just appalling. But there was one huge exception to this rule, a place that did things differently.
Athens. Absolutely.
Yeah.
This is a key moment in legal history. Under the laws of Solon, back in the early 6th century BC, enslavement for debt was forbidden.
What did they call it?
The Sisyphia. It means the shaking off of burdens. It was revolutionary.
Let's just pause on that. What principle did that establish by saying you can't enslave a citizen for debt?
He established that a citizen's personhood was more important than a creditor's property rights. Your body was off limits as collateral.
Which had a huge practical effect.
It meant that most of the slaves in Athens were foreigners because their own citizens were legally protected from that fate. A huge shift.
It's an early sign that society might be better off not completely destroying a citizen over a debt. But that severity didn't just disappear. Let's jump forward. The first formal English law doesn't show up for a long time.
Right. Not until 1542, under Henry VIII, the Statute of Bankrupts. And even then, it was very punitive. It was aimed more at punishing fraudulent merchants than offering any kind of relief.
So still creditor-focused.
Very much so. But if you think that's tough, you have to look at the laws of Genghis Khan, the Yasa.
Oh, I've heard about this.
It makes the English law look incredibly gentle. The Yasa had a provision that it mandated the death penalty for anyone who went bankrupt 3 times.
Death. For failing financially 3 times.
Death. It tells you that financial failure wasn't seen as a misfortune. It was seen as a deep societal weakness, a crime against the market order.
The goal was deterrence through elimination. No second chances there.
let alone a third.
And it's not just individuals. Entire nations can fail. Sovereign defaults.
Right, and this is fascinating because there's no global bankruptcy court for countries. But it has happened over and over again throughout history.
And a prime example comes from Spain's golden age.
Philip II of Spain. He was one of the most powerful rulers on earth, with an empire flowing with silver and gold from the Americas.
And yeah.
He declared state bankruptcy 4 times, in 1557, 1560, 1575, and 1596.
How is that even possible with all that wealth? How do you go bankrupt 4 times?
War. Constant, incredibly expensive wars against the Ottomans and the Netherlands, the Spanish Armada. The cost of empire just outstripped his income. When the interest payments on his loans got too high, he just stopped paying.
Which must have frozen credit markets across all of Europe.
Every single time. It just goes to show that no one is immune to overextension. And while a state doesn't get liquidated like a company,
The consequences can still bring it down.
exactly, the economic chaos can be the final straw. A great example is the Sui dynasty in China.
After their war in 614 AD.
Yes, the Goguryeo-Sui War. It was a disaster. The cost was so immense it led to hyperinflation, forced labor, famine.
So the financial strain was the root cause.
It completely destroyed the system's legitimacy. The dynasty collapsed within 4 years. So even without a formal court ruling, financial failure can absolutely be the catalyst for state collapse.
That history is just, it's brutal.
Yeah.
From debt slavery to execution. So the modern era really is a complete philosophical reversal.
It's a massive shift. The main goal of modern insolvency law, especially for businesses, is no longer about punishment or elimination.
It's about preserving value.
Precisely. There was this huge economic realization that just liquidating an insolvent company often destroys more value. You lose jobs, you lose production, intellectual property, than if you try to save it.
So the law's goal changed from punishing the failure to enabling survival.
Right. The goal is now to remodel the company's financial and organizational structure. You want to rehabilitate it to help it continue. Liquidation is the last resort, not the first step.
And that philosophy gets even more important when we talk about, private households. It's about human recovery.
Exactly. For individuals, it's not just a get-out-of-debt-free card. It's about figuring out the underlying problem. Was a medical emergency, a job loss, poor financial literacy?
And then trying to fix it so it doesn't happen again.
Right. And that requires integrated support. You see this a lot in the European context.
What does that support look like?
It means things like mandatory debt advice, supervised periods where your spending is monitored, financial education classes, and even social help to try and stabilize your income.
So it's a very active process. You have to participate in your own recovery.
You do. Most EU member states require you to make some partial payments and follow behavioral rules to get your debts discharged. But there's a huge range. The UK is probably the closest to the US model, which is more focused on a clean slate.
And what's on the other end of that spectrum? A country that's much more restrictive.
Spain is a great example. Their 2003 law, the like and concurs, allows for debt settlement plans. You can get more time to pay, maybe up to 5 years, or you can get your total debt reduced by up to half.
Up to half. So you could go through this whole process and still owe 50% of what you originally did.
Yes, and crucially, the Spanish law does not foresee a full debt discharge. That remaining balance doesn't just go away, you still owe it.
Wow. So it's about making the debt manageable, not eliminating it.
Exactly. It keeps the debtor accountable, but it means they could be carrying that debt for life.
Speaking of debt you can carry for life, we have to talk about the elephant in the American room.
Student loans.
Student loans. They are notoriously almost impossible to get rid of in bankruptcy in the U.S.
They are. It really goes against that whole fresh start philosophy. The reason they're carved out is that there was this fear initially that new graduates like doctors and lawyers would just file for bankruptcy right away and wipe out all their loans.
Okay, I can see the logic there.
But the law has gotten so tight over the years that now the hurdle is incredibly high. It's defined by something called the Brunner test.
And this isn't a simple math problem. You have to prove 3 separate, very difficult things to the court.
That's right, all 3. And the first one is just proving you're in dire financial straits.
So factor 1 is that if you had to repay the loan, you couldn't maintain a minimal standard of living.
Right. Not that it would be hard, but that you literally could not afford basic food, shelter, and healthcare. It's a very high bar.
Okay, so that's the first hurdle. What's the second?
The second is that you have to prove this situation is likely to be permanent, that your financial problems will probably continue for most or all of the repayment period.
So you basically have to prove to a judge that your future is hopeless.
It sounds bleak, but that's essentially it. You have to show something like a permanent disability or a situation that will never let you earn enough. A temporary job loss usually isn't enough.
You're arguing you'll never recover financially.
Yes. And then the third factor is about your past actions.
You have to show you've made a good faith effort to repay the loans before filing.
You do. You can't have just ignored the debt for 10 years. You need to show you tried to work with the lender, maybe get on a payment plan, ask for deferment.
And even if you manage to prove all three of those things, destitution, permanence, and good faith,
The court might still only grant you a partial discharge.
it's incredible. It just shows how protected that specific type of debt is in the system. All right, so we've gone from the legal difficulties of the Brenner test to, well, outright criminality, because this whole system depends on people being honest.
And where there's a chance for a fresh start, there's always an opportunity for fraud. Bankruptcy fraud is a major white-collar crime,
At its core, it's about deceit, right? Lying to the court or to your creditors.
usually by hiding assets to stop them from being seized and sold. But it can also be filing false information, filing in multiple states at once, or even bribery.
And because this is all happening in a federal court system in the U.S., any lie can be prosecuted as a federal crime.
Exactly. It's perjury. The U.S. statutes focus on whether the person knowingly tried to deceive the system.
And the most common way people fall into this, what you call the concealment trap, is by not listing assets they think are worthless.
This is such a critical mistake. People think, oh, my old car doesn't run, or this collection of stamps is just junk. I don't need to put it on the forms.
And that's a huge problem.
A catastrophic one. Because you are legally required to disclose everything. It's not your job to decide what an asset is worth.
Whose job is it?
It's the job of the trustee, the person the court appoints to represent your creditors. They get to decide if that broken-down car has valuable parts, or if one of those stamps is a rare collectible. By leaving it off, you've committed fraud.
So walk me through what happens. Let's say someone hides a valuable painting, gets their debts discharged, and then a year later, a creditor finds out about it.
The trap snaps shut. A creditor, or the U.S. trustee, can ask the court to reopen the case. The trustee will seize that painting and sell it.
And the debt.
The discharge of debt the person received can be revoked.
Huh.
So all that debt comes flooding back. And on top of that, they can now face federal prosecution for fraud and perjury.
The lesson is disclose everything.
Absolutely everything. The system demands total transparency.
Now that's criminal fraud, but we need to make a clear distinction between that and something called strategic bankruptcy.
Which is completely legal.
Yeah.
Strategic bankruptcy isn't about hiding things or lying. It's about using the bankruptcy laws to your best advantage.
So you're genuinely in financial trouble, but you're timing your filing or using a specific chapter to get the best possible outcome.
Exactly. An example of fraud would be, moving all your cash to an offshore account a month before you file.
Right.
An example of strategy would be a large corporation filing for Chapter 11, specifically so they can legally get out of some very expensive long-term contracts or leases that are sinking the business.
It's aggressive, but it's playing by the rules.
It's using the law as it was written. It's a tool, not a crime.
Now, as we look around the world, one of the first things you notice is that the word bankruptcy itself can mean different things, can't it?
It can. And the biggest difference is whether you're talking about a person or a company.
Okay, so in places like the UK, Australia, Ireland, and Finland,
The term bankruptcy is reserved strictly for individuals. Only a person can be declared bankrupt.
so if a big company in London goes under, what's it called?
They go into liquidation or administration. They use corporate insolvency procedures. But you'll never hear a news report say a British company has gone bankrupt. It's just not the right legal term.
But that's the complete opposite of the North American model.
Right. In the U.S. and Canada, the word bankruptcy is used much more broadly. It applies to insolvency proceedings for both people and businesses. That's why you hear about a company filing for Chapter 11 bankruptcy.
Let's put a spotlight on Australia, which follows that individual-only model. How does it work there?
It's all governed by a federal law, the Bankruptcy Act 1966. And you can end up in bankruptcy either voluntarily or involuntarily.
Involuntarily. A creditor can force you into it.
They can. If you owe a creditor at least $5,000 from a court judgment and you don't pay, they can ask the court to issue a sequestration order, which legally makes you bankrupt.
And what about if you do it yourself?
You file a debtor's petition with the Australian Financial Security Authority, or AFSA. You have to provide a detailed statement of affairs listing everything you own and owe.
And how long does it last?
A standard bankruptcy in Australia lasts for 3 years from the day you file that statement.
During that time, a trustee is monitoring you, and that monitoring seems pretty intense.
It is. A key difference from other systems is the control over your travel.
Wait, what?
If you are bankrupt in Australia, you need to get written permission from your trustee to travel overseas. If you try to leave without it, the federal police can stop you at the airport.
That is a serious restriction on your personal freedom.
It is. It's designed to make sure you comply and don't try to hide assets abroad. And if you don't comply with other things, like making required income contributions,
There are consequences.
the trustee can object to your discharge, which can extend your bankruptcy for another 3 or even 5 years. It's a big deal.
And like in the US, some of your assets are protected. They're exempt.
Yes, things like basic household goods, tools you need for your job, and a car up to a certain value are protected. But anything else, like equity in a home, can be sold by the trustee.
Can you get out of the 3 years early?
You can. It's called an annulment. The easiest way is to pay all your debts in full. More commonly, you can make an offer of composition to your creditors.
A settlement offer.
Exactly. You offer to pay a certain amount, say 50 cents on the dollar. If enough of your creditors agree, you pay that amount, and your bankruptcy is annulled early.
Okay, that's Australia. Now, the Netherlands has a very different, very structured system.
It's very clear. The Dutch Bankruptcy Code has 3 separate proceedings, depending on who you are and what the goal is.
So what's track 1?
That's faillissement. It translates as bankruptcy, and it's only for companies. And its only goal is liquidation, winding the company up.
So that's like a corporate Chapter 7, track 2.
Surcens, van betailing, suspension of payments. This is also only for companies, and it's their reorganization tool. It's like Chapter 11, giving the company protection from creditors so it has time to restructure.
And the third track must be for individuals.
Right. It's called Schuldsanering, or debt reorganization. It's a court-ruled process where a judge appoints an independent monitor to basically take over the person's finances and supervise everything during the repayment plan.
That sounds intense, but it's different from the Australian model.
It is. While you lose your financial autonomy in the Dutch system, you don't have those same punitive restrictions on travel. It just reflects a different philosophy of enforcement.
These global differences really show how complex this all is. But now we have to dive into arguably the most intricate and influential system in the world.
The United States Bankruptcy Code, Title 11 of the U.S. Code.
And this isn't just some law Congress passed. This power is written right into the U.S. Constitution.
It is. Article 1, Section 8 gives Congress the power to establish uniform laws on the subject of bankruptcies. The founders recognized that this was a national issue that needed a consistent federal approach.
But, and this is a huge but, even though it's a federal law, state law plays an enormous role.
A decisive role, especially when it comes to exemptions.
And exemptions are the list of property that you're allowed to keep that the trustee can't take and sell.
Exactly. And Congress decided to let the states set most of their own exemption laws, which means there's massive variation from state to state.
Which can lead to wildly different outcomes for people in pretty similar situations, just depending on where they live.
Absolutely. The classic example is the homestead exemption, which protects the equity in your home. States like Texas and Florida have, generally speaking, an unlimited homestead exemption. You can protect a very valuable home.
While other states are much more limited.
And even neighboring states can be different. Maryland lets you protect the first $6,000 of property or cash. Right next door, Virginia's exemption is typically $5,000. That extra $1,000 can make a huge difference if you're trying to start over.
So state law determines what you keep. But the moment you file, the most powerful protection of all kicks in, and it's purely federal.
The automatic stay.
The instant shield.
It is. It applies to every kind of filing, 7, 11, or 13,
Yeah.
and it happens immediately. The second your petition is filed with the court, a legal stay goes into effect that stops almost all collection activity.
What does it stop, specifically?
It stops lawsuits, repossessions, foreclosures, evictions, wage garnishments, harassing phone calls, collection letters. It's designed to give you immediate breathing room.
It's the big red pause button.
It is.
Yeah.
And once that shield is up, you proceed under one of the main chapters. Let's start with the most common one for individuals, Chapter 7.
Straight liquidation.
This is the quickest and simplest form, usually over in 4 to 6 months. The goal is to eliminate unsecured debt credit cards, medical bills, personal loans. You surrender your non-exempt property, the trustee sells it, and you get a discharge.
But not everything gets discharged. We know student loans usually survive.
Right. And so do things like child support, alimony, recent tax debts, and fines from criminal cases. Those are seen as debts to society or family that you can't just wipe away.
And you can't just choose to file Chapter 7. You have to qualify. You have to pass the means test.
The means test is a controversial and very complex hurdle that was put in place in 2005. The idea was to stop higher income people from using Chapter 7 and force them into a repayment plan instead.
How does it work? What's step one?
Step one is simple. The court looks at your average income for the 6 months before you filed and compares it to the median income for a family of your size in your state. If your income is below that median, you pass. You can file Chapter 7.
And if you're above the median?
Then you go to step 2, which is much more complicated. You have to do a disposable income calculation.
And this is where it gets tricky.
Very tricky. You start subtracting your monthly expenses, but, and this is the key part, you have to use national and local standard expense amounts set by the IRS, not necessarily what you actually spend.
So wait, even if my rent is $2,500 a month, the IRS standard for my area might only be $1,800, and that's the number I have to use.
That is exactly right. The test is designed to be tough. After you subtract all those standardized expenses, if you have more than a certain amount of disposable income left over, you fail the test.
And you're forced into a repayment plan.
You're presumed to have the ability to pay something back, so you'll have to file Chapter 13.
Okay, so that's the consumer liquidation path. What about the big businesses, the lifeline for corporations?
That's Chapter 11. This is the gold standard for corporate reorganization. It allows a business to keep operating while it restructures its debts and tries to become profitable again.
And the strange thing here is that the same management team that ran the company into the ground often gets to stay in charge.
That's the concept of the debtor in possession, or DIP. The company's existing management continues to run the day-to-day business, but now they're doing it under the supervision of the bankruptcy court.
And they have a duty to the creditors now.
Fiduciary duty. Their job is to create a plan of reorganization that details how the company will survive and how it will pay back its debts over time. Creditors get to vote on that plan.
And if it's approved, the company can emerge with less debt and a healthier balance sheet.
That's the goal. It's a very powerful tool for survival. And you'll sometimes hear people in finance talk about a Chapter 22.
What's that?
That's just slang for a company that's filing for Chapter 11 a second time.
Okay, so we have Chapter 7 for liquidation and 11 for reorganization. The third main one is Chapter 13.
Chapter 13 is the wage earner repayment plan. This is for individuals who have a regular income but need help. It's often for people who failed the means test for Chapter 7 or for people who want to save their house from foreclosure.
And the big difference is you get to keep all your property.
You do. Even property that would have been sold in a Chapter 7. The trade-off is that you commit to a 3 to 5 year repayment plan. You pay all of your disposable income to a trustee each month, and the trustee distributes it to your creditors.
And how long is the plan? 3 years or 5?
It depends on your income. If your income is below your state's median, it's a 3-year plan. If it's above the median, it has to be a 5-year plan.
And at the end of that period, if you've made all your payments,
You get a discharge of any remaining eligible debt. But it's a long haul, and if you miss payments, the case can be dismissed, the automatic stay disappears, and you're right back where you started.
we've established that in some countries, like Canada, bankruptcy means liquidation, full stop. So they need different tools if they want to restructure and survive.
They do. For individuals in Canada, the main alternative to a personal bankruptcy is something called a consumer proposal.
And what is that exactly?
It's basically a formal settlement offer you make to your creditors through a trustee. It's for people with debts under $250,000, not including their mortgage. You propose to pay back a percentage of what you owe over a maximum of 5 years.
And why would creditors agree to take less than what they're owed?
Because the alternative is that you file for personal bankruptcy, where they would get even less money, maybe just pennies on the dollar after everything is sold. A consumer proposal is almost always a better deal for them.
A bird in the hand.
Exactly. And once they accept it, all collection action has to stop.
And what about for big Canadian companies that need that Chapter 11 style protection?
They use a law called the Companies Creditors Arrangement Act, or CCAA. It's for businesses with more than $5 million in debt, and it does exactly what Chapter 11 does. It pauses all creditor actions and gives the company time to come up with a survival plan.
Okay, let's jump back across the pond to the UK. We mentioned involuntary bankruptcy there.
Right. A creditor who is owed at least £5,000 can petition the court to force a person into bankruptcy.
Why would they do that? It sounds expensive and aggressive.
It's usually not about getting the most money back. It's about control and investigation.
Yeah.
Sometimes it's to force the sale of a major asset, like a house.
What more often?
It's to punish the debtor, or, more strategically, to get the power of the trustee on their side. Once someone is bankrupt, the trustee can go in and do a full forensic audit of their finances, subpoena records, and uncover hidden assets.
So the creditor is essentially using the system to hire a detective.
That's a good way to put it. But the UK system itself has gotten much more debtor-friendly. A bankruptcy there now usually only lasts for a maximum of 12 months.
That's a huge difference from the 3 years in Australia.
It's all part of that fresh start philosophy. And a really key change they made back in 2000 was to protect pensions. Now, generally, your occupational pension is safe and can't be seized in a bankruptcy.
Which is a huge deal for someone's long-term security.
A vital safeguard. It separates your future from your present failure.
And that idea seems to be part of a much broader trend across the entire European Union.
It is. After the financial crises in the early 2000s, there was a realization that too many businesses were just ending up in liquidation. It was destroying economic value.
So they looked for a better model.
They did. And they looked to the U.S. Starting around 2013, countries like France, Germany, Spain, and Italy all revamped their laws, modeling them on Chapter 11.
The goal was to shift from liquidation to restructuring.
Exactly. To give businesses a real chance to survive a crisis. And it ties into this bigger EU policy goal they call the second chance.
A second chance for entrepreneurs.
Right. The philosophy is that failure is a natural part of business and innovation. The legal system shouldn't punish it permanently. It should give honest entrepreneurs a path back to developing a new business.
So we've come on this incredible journey. We started with the literal broken bench of Renaissance Italy, went through the horrors of debt slavery,
All the way to these highly complex, structured legal frameworks we have today that are designed to manage failure in a way that, well, benefits everyone as much as possible.
It's all about trying to find that balance, isn't it? The creditor's right to be paid versus the debtor's need for a fresh start.
That's the fundamental tension. And we've seen how the focus has shifted so heavily toward rehabilitation. The UK's 12-month term, the EU's second chance policy, the power of Chapter 11.
The whole trend seems to be about preserving the debtor, whether it's a person or a company.
It is. And that's what makes that one big outlier in the U.S. system so stark.
You're going back to student loans.
I have to. Because if the whole purpose of modern bankruptcy law is to allow for rehabilitation, to ensure a minimal standard of living, to give people a fresh start,
Then what does this very specific, very difficult carve-out tell us?
what does it say about our priorities? When this one particular class of debt is so protected that a borrower has to prove near permanent destitution just to get a partial discharge. In a system built on second chances, it forces you to ask which debts we as a society have decided are more important than that second chance itself.
It suggests a really deep conflict in our economic and maybe even moral calculus about what debt is for and who ultimately has to pay for it. A really profound question.
It is, and it's a tension point that you, the listener, should definitely continue to think about.
Something to mull over indeed. Thank you for joining us on this deep dive into the broken benches and complex chapters of bankruptcy law. We'll see you next time.